Hello everyone, and welcome to NAACPConnect.org. I'm Larry Brown Jr., and you are watching another live chat right here with NAACP Connect. The entire United States of America has been abuzz these past few weeks with what some people have been seeing online as #SCOTUS, which stands for the Supreme Court of the United States. Today, the NAACP we've hosted this forum today to engage you in a discussion to talk about some major decisions that are affecting you and me and everyone in this live chat, and they matter most to the NAACP at this time in our lives. We're going to first talk about Doma. We're going to talk about Fisher versus UT, which is University of Texas. We're going to talk about the Voting Rights Act. We're using the hashtags today, #NAACPYC, which represents our Youth and College Division. When we talk about Doma, we'll be using #DOMA. We'll also be using FISHER for Fisher, and we'll be using #VRA or Voting Rights for our voting rights discussion. Joining me today in the Hangout are three great colleagues of mine here at the NAACP, three great young thought leaders and folks who are positioned to carry the banner of social justice advocacy into the future. I'd like to first introduce Joteka Edie. She's no stranger here to our live chats. Joteka is a senior director of the Voting Rights Initiative here at the association, in addition to the senior advisor to the president and CEO. Joteka, how are you this afternoon?
I'm well. How are you?
I'm great. Thank you so much for joining us. After Joteka, we've got Keela Crane. Keela Crane is the Charles Hamilton Houston Law Fellow in the legal department here at the association. Keela, thanks for joining us today.
Thank you so much for having me. It's great to be back.
Absolutely, absolutely. Thank you so much for coming. And finally, we've got a newbie joining the group. We have Sammy Dow. He's no stranger to the association, but this is his first live chat with us here at NAACP Connect. Sammy is the director of the Youth and College Division. Sammy, how are you?
I'm well. Hope you are as well, Larry.
I am. Let's go ahead and jump right into it. Let's deal with Doma. On May 19th, 2012, the NAACP National Board of Directors passed a resolution supporting marriage equality. At a meeting of the 103-year-old civil rights group at that time, the board of directors, the organization decided to support marriage equality as a continuation of its historic commitment to equal protection under the law. Today, June 26, 2013, SCOTUS found the Defense of Marriage Act, which is Doma, unconstitutional. Doma is a United States federal law that allows states to refuse same-sex marriages performed under the laws of other states, and until a portion of the act, Section 3, was ruled unconstitutional today by the Supreme Court, restricted federal marriage benefits. Joteka, you being the senior advisor to the president and CEO, what has been President Jellis's thoughts today for this victory for the association?
Well, first of all, Larry, President Jellis, and I think his statements and the statements of the NAACP today is one of really very much pleased with the court's decision. The NAACP, since our founding, has always valued equality under the law. President Jellis, and I just want to share his statement that was out today, and he says, I quote, "Less than 5 decades ago, my parents' interracial marriage was deemed illegal until Mildred and Richard Loving and the NAACP stood before the Supreme Court to demand that they be treated equally. Today, the principles that led to the victory for the Lovings and my parents are reaffirmed by the court's historic decision. These decisions today bring our nation closer to achieving the equality under the law that the NAACP has fought for since our founding." I think it's really interesting and important to note that the NAACP views equal protection and equality under the law. It stretches for everyone in our nation, and today's decision by the Supreme Court to uphold the fact that it is important that people of all, of course, races, but it also includes people that are lesbian, gay, bisexual, or transgender, also have those same equal protections under the law.
Thanks so much, Joteka. Keita, let's look to our general counsel's office, Kim Keenan. Kim released a statement today as well, correct?
Absolutely, right. And the General Counsel obviously is in lockstep with what our President and CEO said today. The General Counsel from our office said that, just as Joteka said, that equality has no gender. She recognizes, as we all do here at the NAACP, that we are fighting for equality for all people, regardless of your race or your gender or your sexual orientation. The General Counsel stated that the NAACP has strongly advocated for marriage equality because it is a necessary step in the fight for civil rights for all. For 104 years, that is exactly what the NAACP is doing, and we will continue to fight. And so we were very pleased with the Supreme Court's decision today, because in 1996, the Congress had coded into law discrimination, and that is not what the NAACP is about. We have been fighting diligently to eradicate all forms of discrimination, and this is one form that was knocked down today. So she was very pleased, as our President and CEO was.
Thank you, Keila. I think it's highly important that we really do celebrate this as a victory. It's one of the victories that we've had here at the association that has come quick. As I said earlier, this resolution was passed May 19th last year. So just a little over a year and a month, we've seen the Supreme Court take an action favorable to the opinions of the NAACP. I'd like to turn now to a statement from our chairman, Rosalind McAllister Brock. Chairman Brock says that this is a historic day for all Americans. The federal government can no longer discriminate against some couples and cause pain, uncertainty, and financial harm to some families. Today, the Supreme Court acknowledged and affirmed that all loving, committed couples who are legally married deserve equal rights and protection under the law. That's from our chairman, Rosalind McAllister Brock. Again, we celebrate this victory with the Supreme Court. Let's move on to Fisher versus the University of Texas. This is a United States Supreme Court case, or a SCOTUS case, concerning the affirmative action admissions policy at the University of Texas at Austin. Sammy Dow, let's turn to you and talk about the overview of the Fisher case.
So Abigail Fisher and Rachel Michaelwitz applied to the University of Texas at Austin in 2008, and they were denied admission. The two women, both white, filed lawsuits saying that the university had discriminated against them on the basis of their race in violation of the 14th Amendment's Equal Protection Clause. It's interesting to note that the University of Texas at Austin accepts students in the top 10% of each Texas high school's graduating class, regardless of their race, under a law and a statute in the state. And in 2008, 81% of Texas's freshman class was admitted under that plan. They were admitted under that plan. It's also interesting to note that Fisher, who did not graduate in the top 10% of her class, she actually was in the top 12% of her class, says that the university didn't take into account her extracurricular activities and her scholastic achievement, and so she then filed suit saying that we needed to reevaluate the processes associated with affirmative action and UT's admissions.
Great. So, Keila, the Supreme Court had a ruling that seemed a little weird to some people. It seemed a little strange. Can you help us break down and kind of take it out of the gray zone and make it a definitive color here?
Okay, sure. So what happened was that the Supreme Court basically said that the Fifth Circuit, so just for a little bit of a background, in the federal court system, we have different tiers. We have district courts in all of the states, and some states have several district courts depending upon how big they are. And then you have circuit courts. There's 9 circuit courts, and then there's a federal circuit. Texas happens to be in the Fifth Circuit. So the court said that the Fifth Circuit, Circuit Court of Appeals did not apply the correct standard, which is a heightened standard, to Abigail Fisher's case. And so they're sending it back to the Fifth Circuit for them to apply the correct standard. Now, we call this, it's a mixed kind of it's a mixed feeling for us here at the NAACP, because we're very happy that, as our general counsel stated on Monday, that the Supreme Court wanted to ensure that we apply the Grutter standard. The Grutter case was the University of Michigan Law School case that was decided in 2003, and stated that there is a compelling interest, there's a strong interest for all universities and colleges to have a diverse campus. And diversity includes racial diversity. And so our general counsel was pleased that they wanted to uphold the Grutter standard to allow universities to consider racial and ethnic diversity. So they did not overrule, or they did not decide at all, actually, and the justices clearly state that they did not decide whether or not to overturn Grutter in this case. But what they did do is say that it has to be reviewed under the highest standard. However, we are more than confident that when the Fifth Circuit goes back and reviews this case under the proper standard, that the University of Texas at Austin's admissions policy will be upheld. We feel that, and we have looked at this as the NAACP files an amicus brief, which means it's a friend of the court brief with the Supreme Court, stating our support for the University of Texas's position in this case, and stating that the University of Texas used the proper procedure as the case in Grutter outlined. It uses race as a factor of multi-factors. It's a factor of a factor in evaluating and having a diverse campus. We all want to be able to learn, as our general counsel says, we need to be able to learn from a diverse group of young people at our colleges and universities. And diversity is very important. I mean, you guys are together all the time, and my experience is different from someone else's experience. So having a rich, diverse campus is essential. And so that's basically what the Supreme Court said, that the Fifth Court needs to look at it under the heightened standard. But as I stated before, we are more than confident that when they do, the Fifth Circuit will uphold the policy yet again.
Do we have an idea, Keila, of when the Fifth Circuit will actually hear this case?
We do not, but as soon as we do, we will make sure that Sammy in the Youth and College Division office finds out, and make sure that all of our units across the country know, but we will be keeping a very close eye here in the Office of the General Counsel, and to keep our units across the country abreast of when the Fifth Circuit will look at it again.
Awesome. Thank you so much. And
sure.
For everyone watching today, you can make sure that you follow at NAACPConnect on Twitter, or if you like mobile updates, we will keep you abreast and apprised of what's going on as it happens with the Youth and College Division. All you have to do is pull out your mobile phone here, and you can text the word CONNECT, CONNECT, to the numbers 62227. That's CONNECT to 62227. Subscribe to the Youth and College updates, and you'll be sure to get those updates as it relates to Fisher versus University of Texas / affirmative action, and looking ahead to the future, voting rights. Unfortunately, the NAACP received, well, the nation, I should say, was outraged by the decision of the Supreme Court as it relates to their decision for the Voting Rights Act with Section 4 and Section 5. I want to go to our friend Joteka Edie here. Joteka, you have been on the front line as it relates to this fight from the very beginning. At the last time you were joining us, or at the last time you were a guest on the chat, we were preparing to go rally just days later on the steps of the Supreme Court. Now we have a decision. Let's back up a little bit, Joteka, and give us an overview of what took place.
Well, thank you, Larry. And, yesterday's decision by the U.S. Supreme Court, in my opinion, in the opinion of many voting rights advocates, is that this was an act of activism by the court. The court essentially, and I know Keila will break down what the Supreme Court actually said, but what they essentially determined and decided in the Shelby County versus Holder decision, they essentially invalidated Section 4 of the Voting Rights Act. Now, it's important to understand what the Voting Rights Act is. In 1965, there was a historic moment where the United States Congress, within its powers as defined by the 15th Amendment, passed the 1965 Voting Rights Act. And the Voting Rights Act has within it several tools that can be utilized to ensure the protection of voting rights, particularly given that we found ourselves in a climate and continue to find ourselves in a climate in our country where the voting rights, particularly people of color, are often intentionally threatened, intentionally disenfranchised across our nation. And so one of the most important tenets, one of the most important tools of the Voting Rights Act was Section 5. And Section 5 was the mechanism for which any jurisdiction that fell within a formula, which generally was a state or a county or region that had a particularly egregious past of racial discrimination and discrimination in its history, was subjected to a preclearance, which meant that no law, no election change, whether it's an institution of a photo ID bill or whether it is the moving of a polling location, could take place without it being pre-cleared by the Department of Justice or by a federal court, three-judge panel. And that's important because what Section 5 essentially did was it prevented discrimination before it started. Now, it's important to note that the Supreme Court did not invalidate Section 5 on its face. But what they did do was rule unconstitutional the formula for which Section 5 states are determined. And by doing that, it essentially, if you could imagine having a car with no keys, while we have Section 5, the decision by the Supreme Court ultimately rendered the Department of Justice no teeth to actually enact Section 5. And so now we are now faced with what is the wild, wild west of voter suppression. We've already seen states such as Texas and Mississippi and South Carolina and North Carolina begin to echo and say that they're moving very swiftly to implement photo ID and other voter suppression measures. We expect to see the same type of mischief coming from local municipalities who have the decision and authority around polling locations and the purging of voters. But without Section 5 or the ability to enforce Section 5, because essentially there's no formula, we're in a very dire situation. Yes, the NAACP and voting rights advocates, we're outraged. But just because there's been a setback, it's important to know that it is not the end game. It's not the end of the story. This is the beginning of a new chapter. And now more than ever, it is vitally important that we are organizing, that we are sending a message to Congress, that we are saying democracy deserves a vote, that voting rights and protecting voters is of vital importance, and that we are saying to Congress that we are watching. And we're not just watching you, we're going to be calling you, we're going to be visiting you, and we're going to be ensuring that you are taking action. Because there are millions of voters that are at stake right now, right this minute, right this second, in our nation, in jurisdictions that were covered under Section 5. And that is 14 states, 9 states in whole and 6 states in part. So it's really important that we are very, very clear that we must organize. And I really want to say to everyone listening, if not now, when? And if not us, who? We've often said that we should have been born in a time where we can march and that we could have been a part of the civil rights movement and we could have marched on the March on Washington. Well, our time is now. This is a Joshua moment. And it is a time for us to stand up and organize and make sure that voting rights are protected, not only for those that are living under all of the rule of law in this country right now, but for those that will come for generations before us and after us.
Thank you so much, Joteka. Keela, let's talk about the legalese of all of this. So many times we were waiting on bated breath every single day, Monday and Wednesday. Then it turned to Monday and Thursday, Monday
Yes, we
and
were.
Thursday of the second week, and then this week it was Monday, Tuesday, Wednesday. And at 10:15, we log on a SCOTUS blog and we hear the clicks, and we're waiting to see what decisions are going to be. And finally, when the decisions come down, we see all of this jargon, essentially, that a lot of people who don't have a JD don't understand. So break down in layman's terms, simplest forms, what the Supreme Court pretty much said.
Okay, a lot of people with JDs, it took us a while to parse through all the language, so don't worry about it, you guys. I mean, it was a lot going on in that case. Sorry, there's a little thunderstorm, so if I know my screen is a little bit darker, but we're going to rock out anyway. You guys will work with us.
Absolutely.
So what the court basically said, and what the court said in the voting rights case basically is exactly what Joteka said, is that they said that when the Congress reviewed Section 5 of the Voting Rights Act and Section 4, and basically the entire Voting Rights Act, they looked at Section 4, which is the formula. So as Joteka said, is how are states or municipalities covered under Section 5? They never updated it according to the court. They said that they used old data, even though they had a 15,000 page record. They didn't look at it and change it. They looked at it, but then utilized the old formula. And so the bottom line of it is right now is that, as Joteka said, they decided that the Section 4 was unconstitutional because it compares different states and makes them unequal. It says that Texas has this one standard, but Michigan may have another standard, or Tennessee may have another standard, so it doesn't make the states equal. And it uses old law so to do. And so they're asking Congress to go back, and they're basically asking Congress to go back, look at the formula, look at the data of 2013, and craft a new Section 4. And that's good news for us. Even though yesterday was a very bad day, a horrible day, our office, Joteka's office, we were trying to figure out what this court is trying to say, and it really does make millions of people across the country very vulnerable because they held that this current Section 4 is unconstitutional. And that means that as of yesterday, sometimes, in criminal courts, in a state criminal courts, if something happens, there's an appellate process. And so it may not be, in effect right then, because you can file an appeal. When the Supreme Court says what it is, that's it. There is no higher appeal to go. And so what we have to do is that we have to get our boots on the ground. The young people of the Youth and College Division, and the young people, and maybe not so young people that are watching us today, that means that we have lots of work to do. We need to utilize our Facebook and our Twitter, our Instagram, our Vine, whatever else the new thing is going to be tomorrow, to mobilize and organize to let the Congress know that you need to put in a new Section 4, and we need to do it now. Because as of today, as Joteka said, millions of people are left vulnerable. We agree with Justice Ginsburg, who wrote a beautiful dissent in this case, stating that it was fine that once Congress looked at everything, there was nothing wrong with what the Congress looked at and decided that the Voting Rights Act should be reauthorized for another 25 years. The fact that because of the Voting Rights Act, we have reduced amounts of discrimination, as she beautifully stated, does that mean that you get rid of the very thing that has been helpful? You want to strengthen it. It didn't make any sense to her, and it really didn't make any sense to us either. But that is not, but we will, as our general counsel said, we will demand a fix to this problem. We will make sure that the ideal of one person, one vote, that means that your vote is equal, it has the same weight as my vote. It will be the law of this land, and that just means that we're going to have to do everything that we can do within our power to ensure that a new Section 4 will give teeth back to Section 5 and will put in place those states and then those municipalities that deem it unworthy for some people to vote versus others.
Thank you, Keela. You mentioned Justice Ginsburg. I want to read a quote that we shared from the NAACP's Facebook page yesterday. It says, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not because you aren't getting wet. Those are words from Justice Ruth Ginsburg. You can see that we actually.
Go ahead.
Go ahead, Keela.
Sorry.
Go ahead, Keela.
Oh, exactly. It just doesn't make any sense. You know, if you have something that's going to protect you, you keep it. You know, that's just like if you guys have a scholarship and it might be a half a scholarship here and a half a scholarship there, you're not going to throw out the half scholarship because you haven't. No, you're going to make sure that you have everything that you need so that you can stay in school. It's a weird kind of analogy, but that's the best so that you guys can see that you want to keep something that is protecting you, that's helping you march along to that graduation date, or for us to march along to make sure that everybody has the unfettered access to vote. More than any other type of piece of language or anything, voting is the number one subject for constitutional amendments. There are 5 different constitutional amendments to our federal constitution that have to deal with voting. We have the 15th Amendment, we have the 19th Amendment, we have the 24th, the 26th, and I believe the 29th, if I'm not, no, I'm sorry, the 24th, the 26th amendments to the Constitution. All of those have to deal explicitly, I encourage you guys to look it up, with the right to vote. And so we understand it's very important, and the NAACP, working with Joteka in her office, working with Sammy, and here in the Office of the General Counsel, we will make sure that everyone has the unfettered access to vote.
Thank you, Keela. I want to talk a little bit about the marching. Keela, you talked about marching. Joteka, you talked about organizing and mobilizing. Sammy, I want to pull you in here to talk specifically about how the youth and young adults of the NAACP can begin engaging, getting involved in this, because our aunts and uncles did this already. Our grandparents did this already. We just looked at the 50th anniversary of the Freedom Walk in Detroit, my hometown, this past Saturday. That commemorated Dr. King's walk 50 years ago before he gave the I Have a Dream speech here in D.C. Let's talk about why it's important for people like you and me, young professionals and people in college right now, to be involved in a movement like this.
It's interesting, Larry. Medgar Evers years ago, more than 50 years ago, said our only hope is to control the vote. And we know that that's what Youth in College has the power to do. We have the power to reshape what the new and reformed rules on voting will look like. It's important for young people to be involved in this process because ultimately these laws, these formulas, these procedures, they'll impact us for generations to come. They'll impact our children. They'll impact how we live, the quality of life, how we build our lives. So we need young people in their communities across the country rallying their state legislatures. Let's be clear. This fight has to start at the state level, and it will advance to the national level. We need young people on the ground in their states lobbying their local boards of elections, lobbying their city councils to reaffirm their commitment to providing open and fair access to the ballot box. We need young people on their campuses calling on their university administration and their student government associations to be proactive in affirming their commitment to equitable, open, fair access to the ballot box. We need young people unafraid, militant, and effective to march on their capitals, to call on their representatives and their senators to say, we want action on voting rights. We want our student IDs to be acceptable forms of voter ID. We want young people's voices heard. We want polling locations on our campus. We cannot stop. We cannot run from this opportunity. And it really is going to be young people on the ground making their voices heard, young people on the ground getting arrested as young people in North Carolina are for what they believe in. It's going to be young people on the ground who say, you know what, this is our fight. No longer can we wait for someone else to give us the strategies or the answers. We've now got to take the reins. We've got to take control of this, and we've got to do exactly what our Youth in College mission statement says. We've got to be militant, effective, and intelligent youth civil rights leaders, because we are, as the Youth in College Division, the nation's largest army of youth civil rights leaders in the country, with more than 30,000 young people across 600 active youth council councils and college chapters. And so if not the NAACP driving this, if not the NAACP Youth and College supporting this work, who can we expect to do it? So we've got to be the boots on the ground. We've got to be the soldiers in the field. We have to become the 2013 Medgars and Martins and Malcolms. We've got to become those people. And not only do we have to support the work that our older generations are doing in marching, we've also got to be able to drive work and create our own legacy. And because history will record what we did in this moment.
Great words, Sammy. Great words. What talk about the power of networking? You're challenging all of us to do better, to go forth, to do more, to be the civil rights activists that we've been called to be. Talk directly to the young folks who think that, well, I'm the only one who does it. How can they engage, and how can they engage their peers who may not see this as a pressing issue right now?
So it's easy to feel like you're the only one in your community who cares about this or who's working on it. The thing I found is that if you start doing the work, if you make the noise, guess what? Folks will hear what you're saying and they'll join your cause. Joteka and I oftentimes laugh because she says in her high school yearbook, people would sign and say, oh, Joteka, good luck with repealing the death penalty. And years later, she's had victory repealing the death penalty in states across this country. And so we have to have young people willing to take that same stand, willing to jump out there. If you get out there and you get in front of the issue and folks see you are not ashamed and you're unafraid to advocate, to make your voices heard, to write your op-eds, to call on administration to pass resolutions, then people will join you because they see that you're doing something and they see that you're serious and you're genuine about what you're doing. This movement and this work is more than just the issue. It's about the relationships we build. It's about the levels of community we design. It's about the families we produce. Ultimately, we know that the relationships come when folks feel like you're doing credible, valuable work. They're willing to jump out there with you. They just need young people like the NAACP Youth and College Division to take that first step for them, and they'll join you along the way.
So when this chat is over and done with, if you need help, if you need assistance, at the top of the window, you can go and click the link that says share your stories. At the top of the page in the menu bar, click where it says share your story. Fill out the form. Send us your information. If you need assistance, if you need help, if you want to join, let us know and we will point you in the right direction. This is so important. Every unborn child will be affected by what just happened yesterday. Today, we're being affected by what happened yesterday in the Supreme Court. This will not end. This will not end, and we will carry this forth. I want to go to some questions. Thank you, everyone who's tweeting questions to us and posting them to Facebook. I want to go to a question. I've seen this numerous times today. Phyllis Jones asked something similar to this, and I got a question from @ColgateSmile on Twitter. Joteka, what is the NAACP's plan to expand the electorate? And because 2013 is a major election year in Virginia in November, and the voters face long lines, and she's asking, how do we plan to expand the electorate? Joteka, I think your mic might be on mute. If you can check your settings and then start talking from the beginning.
Yes, I wanted to thank Colgate.
Now we got you.
Yes, I wanted to thank Colgate Smile for that question, and I did reply on Twitter. But what I shared is that the NAACP is committed to continuing our year-round voter empowerment efforts. We know that Virginia is a state that is covered by Section 5, and Virginia recently put forth a new strict photo ID bill, which now will not be held to the standard of pre-clearance. So we can assume that unless Congress has a new formula by the November elections, that photo ID will indeed be the law of the land in Virginia. The NAACP is committed to, one, making sure that every single voter in the state is aware of the law changes, and that we are working in communities to ensure that every single voter has the necessary ID and information they need to cast their ballot. Second, we will ensure that we are registering as many voters as possible. We conduct voter registration all year round, and this decision in no way will stop that. If anything, it is going to propel even more voter registration. out there. We expect, and I've already started seeing, there is going to be a backlash to this backlash. There is going to be massive movement from outrage to action. And that is what the NAACP is going to facilitate. We've been doing that for 104 years, and we're going to continue to do that. And we're going to do that in Virginia. And I promise you, the NAACP is going to turn out, and we're going to be just as strong as we were in 2012. Let us not forget that in 2012, we were having the same conversation because we were seeing massive amounts of voter suppression laws that were passed. And we saw a backlash against that backlash. And the NAACP, along with our partners, shattered the record books. We turned out a historic amount of voters. We registered nearly 400,000 voters. We turned out and touched and put out into the polls nearly 1.2 million voters. And we're going to do that again in 2013, and we're going to do it in 2014. And so it's important for everyone to know that, yes, we did get a setback, but it does not mean that we don't have other tools in the Voting Rights Act. There are other sections, Section 2, Section 3, and we also have the National Voter Registration Act. So there are still protections that we expect the White House and the Department of Justice has echoed that this administration is going to do everything it can to protect voters. But the NAACP is going to make sure we're registering voters, we're educating voters, and we're turning them out.
Excellent. And just so everyone knows, what Joteka was just talking about, the number of voters that we turned out to the polls, the number of voter registrations that we had. Let me tell you, last year the NAACP was 103 years old. That was the largest voter registration campaign that we have had in our own history. So we are challenging ourselves to go above and beyond and top our own record. I'm inviting you to join us right now as a member of the NAACP and say, I will commit to registering people to vote. Even though this is not election season, I'm going to challenge someone to vote and help someone register to vote. Thanks so much for that, Joteka. I want to also ask you this, Phyllis Jones asked another question on Facebook, Joteka. Is the NAACP going to reach out to other groups to help with the voting rights agenda?
I'm sorry, Larry. Could you repeat that question?
Sure. Phyllis asks if the NAACP has plans to reach out to other associations and groups to help advance the voting rights agenda.
I think I heard the question. You cut out a bit, and I think the question, Phyllis, is what is the NAACP doing with partners to advance the Voting Rights Act? I'm sorry, I just want to clarify the question.
The voting rights, yep, the voting rights agenda. Who are our partners? Do we have partners, and if so, who are these partners, and how do we plan to collaborate with these partners?
I can hear the question now, and thank you, Phyllis, for that question. You know, there is a wide group of partners that are fighting to both protect and expand voting rights. I think, of course, you have our partners that we've been working with for years and decades, such as the National Urban League, the National Action Network, the Lawyers Committee for Civil and Human Rights, the NAACP Legal Defense Fund, as well as new allies who have not traditionally worked on voting rights. I think what's important to note is that this entire massive attack on voting rights, it is not just an attack on the civil rights community, it's an attack on democracy. And because of that, we've seen numerous organizations step up and say, this is a problem, and we are going to put the strength of our organization behind fighting for democracy in our country. So we've seen organizations like the Sierra Club. We've seen organizations such as Greenpeace. I mean, a lot of people, they think Greenpeace and Sierra Club, and you immediately think trees and forests and whales, not voting rights. But voting rights is a priority. And what the president of Greenpeace says, you know, they're not going to save many whales, and Sierra Club says they're not going to save many trees if no one has the access to actually elect people into office that are going to put forth their issues on fighting for an environment that we all can live in. And so this attack on voting rights cuts across many demographics, and there are a wide group of partners. And I think that's really important, that all of America believes in our democracy, and all of America across many spectrums are standing up and fighting. When you look at the statements that came out on yesterday, there were statements from environmental groups, from unions, there were statements from business owners and business leaders. There were statements also from the LGBT community, civil and human rights communities, and we're getting calls from all over the world. So everyone has their eye on this, and there's a very broad coalition that's ready to stand up and fight and demand that Congress takes action and demand that state legislatures be sure to make sure that we're protecting every single voter in our country.
That's right. We have a right to vote, and we also have a right to demand and to challenge. Why? It's our civic duty to do things like that. So sticking with you, and Sammy and Keela, if you all know any information on this, I want to talk about that. Joteka talked about the Wild Wild West. You said this is turning into the Wild Wild West of voter suppression. What are the states that are opening up the gates to go to battle, so to speak, with voter suppression right now? I mean, we heard Texas literally 24 hours after, less than 24 hours after the Supreme Court issued their decision.
Yes, there are a number of states that had legislation pending. I think a lot of people noted that there were about 82 measures that were pending earlier in the state legislative session this year. And a lot of people are like, oh my goodness, the election is over and there's all still these voter suppression laws. Well, there were all these laws because people are anticipating a decision, particularly in those states covered by Section 5. So we've already seen in Virginia earlier this year, photo ID put in place. So now they don't have to go through the pre-clearance requirement. Texas is now, Attorney General is saying that their photo ID and their redistricting plan is to go into immediate effect. North Carolina has a massive amount of voter suppression legislation that's pending that we expect to pass any day. Mississippi is asserting that their photo ID is now the law of the land. And we expect South Carolina to move forward with additional voter suppression legislation. So already we are seeing voter suppression on the rampage. And so it's really important that we're not only watching for state legislative actions, but we've got to also watch for what's happening in local jurisdictions. Because, you know, moving a polling place has a dire effect on an election. And so the Section 5 pre-clearance actually held local counties to a standard that if there was a move to move a precinct location, that had to be pre-cleared. And there was just a call this morning where representatives of the Department of Justice shared examples of there was a case in which a local jurisdiction had filed to move a polling location. Well, the polling location, they wanted to move the polling location where a large number of African Americans voted from a school district, a local school, to a private club. Well, everybody in the community knew that the private club was a place where it has long been known to be a very hostile environment to people of color. And so when the Department of Justice replied back and asked for further information, all of a sudden the local jurisdiction decided to abandon their plan. So that's an example of the power of Section 5, and we don't have that anymore. So it's not just these states with law changes, but it's also maneuvers such as the regulations around how voters get removed and purged from the voting booths, in addition to something as simple as moving a local polling location. So there's a lot of states and a lot of local jurisdictions that we need to be on the watch for.
And Joteka, you mentioned South Carolina, your home state. I know that you will not let it go down in South Carolina.
Absolutely not. I am from Johnsonville, South Carolina, and the governor of South Carolina, Nikki Haley. I just really, honestly, would hope that the governor of the state of South Carolina will really move in a manner that protects voters. But we know that she's been clearly on the record of pushing down the throats of South Carolinians' photo ID, and there are going to be a lot of other attempts in the state of South Carolina. But I'm from South Carolina, and my family, my family started calling. And my dad sent me a text message yesterday, and he said, and I quote, we have, my dad is a proud member of the NAACP. He said, we have our work cut out to do, and may God be with us. And so just to echo what my dad said, there's a lot of work for us to do. And I really want to ask the question again, if not now, when? If not us, who? I know young people that are watching us out there. You're very important. And I know that if you can break Twitter down about Northwest and break Twitter down about whether or not Beyonce is bringing into the world her second child, we got to break Twitter down and break Facebook down for voting rights. If we want to get on Vine or Instagram video, whatever your preference, we need to be out there talking about how we need to be fighting to tell this Congress that we demand action and that we need to restore Section 4 so that we can protect voters out there. That is our call to action. That's what we've got to do. It's our time right now. So either we're going to step up or we should just need to move to the side. But I believe that we are going to answer the call. For anybody who ever just longed in their heart to march with Dr. King or to sit with Miss Rosa Parks or to know what it felt like to be Fannie Lou Hamer or to know what it was like to cross the Edmund Pettus Bridge, this is your moment right now to step up and take action because this is our time right now.
And Larry, one thing that I'd like to mention is the North Carolina Youth and College Division, in partnership with the North Carolina State Conference of the NAACP, has been launching what they call Moral Mondays. And they have been, young people have been there on the front lines getting arrested. Young people of all shapes, sizes, colors, backgrounds, educational levels, young people on the front lines of the North Carolina Moral Monday movement, and they are standing up and making their voices heard to the state legislature about not only the voting rights legislation, but the oppressive bills, period, that the North Carolina state legislature is pushing. And we're excited, and I wanted to make sure that we took an opportunity to honor the work of our young folks in North Carolina, my home state.
Absolutely, Sammy. You took the words right out of my mouth. I was going to give you a shout out for North Carolina and mention the hashtag Moral Mondays, # Moral Mondays, so that folks can see what's going on in the ground. I mean, this Moral Mondays is actually taking national legs right now in media. So I admonish everyone to check out and see what's going on with Moral Mondays. Additionally, I want to challenge everybody. I failed to mention that we do have a way that you can take action right now with the NAACP. If you go to the NAACP.org website, you will be able to check out a petition that we have online that invites you to sign the petition to your congressman to tell your representative that they must act now to protect voting rights. I just put the petition up on the screen right now. You can see my personal NAACP email address. So if you wanted to email me after the chat, it's public information right now. However, I admonish everybody to go to the NAACP website, check out this petition, and you can send a letter to your representative telling him, I do not want my right to vote to go away. I don't want the right to vote to go away for my children or anyone else that I'm connected to. I want to go to final thoughts from anyone else. Joteka, you have any final thoughts today before we leave? I think your mic is on mute again, Joteka.
I just want to close by, first of all, thanking you, Larry, and thanking all of the wonderful folks that are out there that are on this
Thank you so much, Larry, and thank you to everyone out there for joining this chat with us and keep the conversation going. Joteka, Sammy, and I are on Twitter. You can, contact our general counsel. She's also on Twitter now. We're so excited about that. At Kim M. Keenan, Keenan. and just speak to us about your concerns or your questions that you may have about any of the 4 decisions that we talked about today. Though the Supreme Court has spoken, we are not going to rest until we have equality and justice for all people. We will not rest until our right to vote is secure. I want to make sure that you're clear that you still have the right to vote, and even though Section 5 only impacted 16 states, either in whole or in part, we need to make sure that everybody understands that we all need to be in the same boat pushing for voting rights for all people. If one person has their right to vote diminished and the access to their right to vote restricted, then that means that my access to right to vote is also restricted. Our home state here in Maryland does not have is not covered under Section 5, but that does not mean that every single day I'm not going to be out there trying to find new ways and try to work with our Washington Bureau to craft legislation to ensure that Section 4 is restored in the Voting Rights Act. We have lots of work to do, but if the young people in the 50s and the 60s were the ones that are out there beating the pavement to ensure that our civil rights were upheld, then the young people of 2013 and 2014 can and will do the exact same thing. As an alumni of the Youth and College Division, a former member of the National Youth Work Committee of the NAACP, a former college chapter president at South Carolina State, I know it's hard work. So I thank you guys so much for the work that you do, but I know that you can do that and so much more. If we can be of assistance to you here in the Office of the General Counsel, please do let me know at K Crane, CRAINE, and I would love to chat with you. Let's keep this conversation going.
We definitely will keep the conversation going. Sammy, final thoughts from you.
So Joteca's, she used a word that's very, very key in her closing remarks. She said we have to agitate. And there's a quote hanging on my wall in the office that I'll share. It says, if there is no struggle, there is no progress. Those who profess to favor freedom yet depreciate agitation are men who want crops without plowing up the ground. And so I'll say to our generation, if we want the crops, if we want the harvest, we have to be willing to plow the ground in this season and in this moment. Join us. Be willing to take a stand. If you want the crops, if you want the harvest, if you want to see the fruit of effective labor, be willing to join the NAACP, be willing to join the Youth and College Division, and let's plow up the ground and make sure that justice and equity is available for all people.
Thank you so much, Sammy. Now, I couldn't agree any more. I read a passage one day that said that the harvest is plentiful and the laborers are few. Will you come and join us? Will you come and stand with the NAACP and be one of the laborers so that we can go forth and reap a bountiful harvest of social justice advocacy for voting rights here in the United States of America? This is a call to action for every human being under the sound of my voice to come and stand with the NAACP. We have a tradition of over 144 years, and we are not stopping because we are the NAACP. We are changing the game in all that we do. I thank Joteca for joining us today. Thank you, Keela Crane, for joining us. Thank you, Sammy Dow,
and my friend Kendra.
Hey, Kendra, who just
We're
walked
busy
into
here in
Keela's
the
office.
Office of the General Counsel.
Yes, everybody. We're doing this during normal work hours, so there is work piling up on our computer. So we're going to end here and let everybody get back to work. Thank you all so much for watching. Tune in. We will have another live chat coming. Make sure you follow us on Twitter for updates and text CONNECT to 62227. I'm Larry Brown Jr., and we will see you next time.